And here we go. Another day in felony court. Right from the start, we learn Jacob isn't new here. He's on probation for felony DWI. Translation: he's already had multiple chances, and this could be his last.
Good morning, sir. You are Letharia Jacob. And Mr. Jacob, you were previously in court, entered a plea of true to count 2, and a motion to revoke your probation. So you're on probation for the 3rd-degree felony offense of driving while intoxicated, 3rd or more. And let me get that pulled up and go through. Does the state have evidence with regard to any of the other counts?
Yeah, sure. Probation. I'm sure. Count 1.
Okay. Sure. Nichols, with regard to count 1, you may call your first witness.
Thank you. State calls Simia Jefferson.
Good morning, Ms. Jefferson. If you please raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you.
Mr. Jefferson, are you the probation officer on behind the
Yes.
How long, please? Part of his condition.
Yes.
What is that for? And so, during the period of supervision with GPS shady the open city counts. She asked me more how else he could get more.
Yes.
What you
Wow. He actually denied going to that.
Busted by technology. These ankle monitors don't lie. When Jacob denies being in Galveston, but the GPS pings otherwise, the court sees one thing: deception. And judges treat lying on probation like pouring gasoline on a fire.
What you get off right?
when was the concept?
It was during officer hours.
Well, check it out. After that conversation, I'm Jason Shaw, State Council, Actually, I'm sorry. While I have you, what is your recommendation for the classroom? No, your attendance in your concluding recommendation.
All right, Mr. Rojas, you may proceed.
No questions.
Okay. Any other witnesses?
No.
Okay. Any witnesses with regard to count 1 then, Mr. Rojas? Mr. Jacob, the best you can, raise your right hand, please, sir. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God? All right. Thank you, Mr. Rojas.
So, first off, she denied her. I backed her up on I worked last time. I think I said I was actually in the money. So, yeah, we're going to kind of what happened. And so, are you going to court today? You show me out, you can see like you want to be kind of really I'm confident. You know, you tell the court that you never can sue you. So, he actually got one more.
Here's the defendant's big chance to explain. Notice the strategy: miscommunication. It's a classic move, shifted from dishonesty to a simple misunderstanding. But will the judge buy it? Or is this just damage control?
I'm fine.
So, who do you work for?
I want to find the
So when your probation officer, Ms. Jefferson, asked you about that, why didn't you get any kind of proof that showed you had been there? She was questioning that you were. Don't talk over me. Let me finish my question. So if you disagreed and with her that you were there for work and not for something else, then why didn't you do anything to give her some information, or your attorney at this point some information?
No, it's trying to do
Mm-hmm.
here. What I supervisor Micah, the one Jacob. Well, that's true. They do work out of town. They go various locations. So he did have me documented what they were working on town. I would deny what it was. He just said works travel out to New Jersey, Cal. Couldn't tell me what it was. Those
Okay. All right. Anything else then? Okay.
And just like that, the judge locks it in. Count 1 true, count 2 true. Remember, probation is like a contract. Break the terms, and the whole deal can collapse. This ruling means Jacob's chances for leniency are shrinking fast.
Well, I mean, the allegation is that you were out of the county without permission. And so you had permission to work. But when something comes up, I would think that there was an issue with regard to whether or not you were working on that day, and you didn't provide any verification of that, then it really doesn't leave me much choice at this time other than to find count 1 true. So I am at this time, based on testimony, going to find count 1 true. Again, there was a plea to count 2 of true. I've received the updated pre-sentence report. Has everyone had an opportunity to review that report? Are there any additions or corrections? And so I want to go through real quick, again for the record, this was a driving while intoxicated, third or more. It was an 8-year sentence that was probated for 8 years. The allegation number 2 that you previously pled true to was that you did not use the handheld breathalyzer as ordered as well, and you pled true to that. So, Mr. Rojas, you may.
What was the vacancy offer? He moved to the breathalyzer, blew into the blank. So that sometimes the job thing, you can occasionally he had to park in the parking lot or on the street somewhere, and they walk to the job site, which is, quite a distance away. And by the time he walked from the job site in the car, the time to go off the machine was trash. That's why he's coming up. So I think no excuse. Just didn't know when he was doing it. But it's not like he was blatantly not going into this according to him. He was doing it, he was just doing it like just because he was at work in the job site for quite a while. I wasn't working in the car. What Mr. Jake was exactly important to do for him is, I know it's hard in the court. He's asking the court to reinstate that. He already been to the JCDI more than once, I believe. I don't think he got any positive or not positive.
Oof, that's the nail in the coffin. Even a tiny blood alcohol reading at 8 a.m. screams relapse. The defense wanted this to look like minor slip-ups, but now the judge sees a pattern of failure.
Just timing on getting it done. I've told him on several occasions about how important this is. That's whenever the court tells him, court tells him when to do it, that's when he's got to do it. I think he understands that. He's asking the court to either not stay in it or go back to the way it was before the motion was filed. I understand. My basis of that, and I think about the issue. I don't know what he's doing on the should be done or not. I don't think why
So, but Mr. Jacob, you can't just keep messing up and then say, okay, I get it this time. Just let me out. I'm going to do it. You were here. Okay.
So I don't think it's your institutions. It's not on the report. One made the comment. The low blood alcohol is fine.
Yeah. It's 0.003 at 81. And then missed subsequent that day. I mean, okay. I want to make sure that I have this right. So it looks like you went to the Unity house for 30 days. Within 2 months of the release from there, and this was at the beginning of your probation. Let me go through. Began JCDI program April 2022, shortly after you got on probation. And so you were struggling to maintain sobriety. You went to the Unity house for 30 days. Within 2 months of that release, you again tested positive for alcohol. You had your first administrative hearing. Part of that was that you get that SCRAM device, as well as increase your recovery efforts.
And there it is, the gavel moment without the gavel. 4 years behind bars. The message is clear. The court gave Jacob multiple programs, multiple chances, and he blew them all. At some point, zero tolerance really means zero tolerance.
In JCDI. Failed to adhere to those recommendations, therefore you were ordered to complete both tracks of ISF, which it looks like you did, completed December 28th of 2023. Then you go back to JCDI for aftercare, again struggled to comply, testing positive, forging your required meetings, and operating a motor vehicle without an interlock. This led to unsuccessful discharge from JCDI and a motion to revoke. And so you came here on a hearing on a motion to revoke. I left you on probation, continued you, ordered you to re-enter the JCDI program. You were going to be on the high-medium caseload, continue with your portable monitoring device, and it was going to be zero tolerance. Then we're here again with failing to comply with that portable device at least, it looks like 19 times. You didn't do that. And then we've got the issue with you being in Galveston and Gilchrist without permission. So it looks to me like you tried and started but never finished JCDI 3 times, I believe. But I'm supposed to just go, and you've been to ISF, and you've been to the Unity House. I mean, when I'm saying that out loud, think about how it sounds for you to go, just let me out this time, I got it. I got it. I'm going to do good this time. You see what I have to worry about? I have to worry about everybody being safe. Mr. Nichols? So, Mr. Jacob, I'm going to find that you entered your plea of true to count 1 freely and voluntarily. Find that count true. I've already found count 2 true based on, no, the opposite. You pled true to count 2. I found count 1 true today. I'm going to find sufficient evidence to revoke your probation, and at this time, revoke your probation. I'm going to reassess your punishment at 4 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification. I need you to sign this, and I'll give you a copy. It shows this was not an agreement, so you do have some rights to appeal. You can talk to Mr. Rojas about that. Good luck, sir. Thank you.